Members, we will now move on to questions to the Minister of Justice, and I call Jemma Dolan.
Can call you question 1, please.
Minister for Justice.
The pain and ongoing anguish that families living in the terrible situation of not knowing where the remains of their loved ones are cannot be underestimated. The recently introduced Helen's Law in England and Wales provides that the Parole Board must consider a life prisoner's failure to disclose information on the location of their victims' remains in their deliberations on whether the prisoner should be released at the end of the tariff period or not. While this is a step forward in recognising the trauma endured by families, it does little to encourage disclosure at an earlier stage. I believe that we have a responsibility to do all that we can to help those families, and a bespoke approach for Northern Ireland offers the best hope of securing disclosure. That is why I commissioned a review to examine opportunities to encourage those suspected, charged and convicted of murder to disclose details of the location of their victims' remains at each stage of the criminal justice process. Good progress has been made over the summer. Having developed their report, my officials met with victims' families on the 2nd of September. Final adjustments are now being made to the report in light of that meeting, and the report will then be with me shortly. I intend to meet with the families of Charlotte Murray and Lisa Dorian once I have had an opportunity to consider the report, and I will set out my formal position in due course.
Supplementary, Jemma Dolan.
And I thank the Minister for that answer. Minister, would you anticipate any proposed changes resulting from the review of the law around the disclosure of victims' remains being legislated for in this mandate?
Well, I don't want, first of all, to preempt what the solutions might be in terms of changes that are required and whether or not they may require legislation. It is clear, obviously, given the mandate and the lack of considerable or additional time we have at this point, that any new legislation is likely to be in the new mandate. However, there may be things short of a legislative response that will be able to be implemented in shorter time, and I will be able to set that out in more detail once I have had full consideration of the report.
I call Dolores Kelly.
Thank you, Mr Speaker, and I thank the Minister for her answer. In terms, Minister, of any correlation between sentencing guidelines and indeed information then in terms of the victims' remains, have you had any stakeholder engagement in relation to that particular principle?
Mr Speaker, it's not an issue in which I've engaged with stakeholders, but it is an area that we can obviously consider as the report comes forward, because there may be some overlap. I think the important thing is that at every interaction with those accused and convicted of these offences, we should be trying to create an incentive for them to give up the location of remains. It is an incredibly distressing experience for families when they have no place to go in order to lay memorials, to lay flowers on a grave. And for many of the families, that distress compounds the loss of their relative. And it has been, to me, absolutely horrendous that there are people within the system who continue to withhold that information. I think it's so important that at every stage and at the earliest stage we incentivise people giving that information up, because we want to limit the amount of time the families have to go through this kind of trauma.
Andrew Muir.
Very much, Mr Speaker, and I want to thank the Minister for her response and also for working with families, including those of Lisa Dorian, who reside in my constituency. Would the Minister agree with me that the most powerful and most important message that can come from this chamber here today is a united message that anyone with any information whatsoever in relation to the disappearance of Lisa or others come forward to the police or to Crime Stoppers to allow their apprehension and also the discovery of their remains?
I would wholly concur. It is a trauma that does not bear thinking about when families lose a member of their family. When they lose them in such horrendous and violent circumstances, and when no one will come forward with that information, yet everyone knows that that information must be available to some people within our community. And so it is absolutely key that those who may have information that could lead to a conviction in such offences and lead to the recovery of remains should make that information available through Crime Stoppers or to the police directly, because it is only right that families should not only see justice, but should see the end of the injustice of not being able to bury their dead. And for the next question, can I call on the Speaker,
Declan McAleer, come on screen, please.
Question number 2.
Mr Speaker, before I answer the question, could I take this opportunity on behalf of the Assembly to express sympathy to the family of the prison officer who sadly passed away on the 19th of August following a short battle with COVID-19. He was known personally to a number of members in the Chamber, and it is right that we pay tribute to him for his work within the prison, and in particular for the work he did in support of staff, both past and present. Turning to the question, I understand that the review of vulnerable people in custody is due to be published by the RQIA during the week commencing the 20th of September 2021. Pending the outcome of this review, Prison Service has been working closely with the South Eastern Trust, our healthcare provider, and has made significant progress in improving support to people who are at risk. For example, we have delivered a joint suicide and self-harm risk management strategy and a joint management of substance misuse in custody strategy, a review of our supporting prisoners at risk procedures, which has resulted in the delivery of a new person-centred approach which aims to support someone through a period of crisis or distress, as well as addressing the root cause of the issue. Wellbeing hubs in each of our establishments, which provide a therapeutic environment for people in our care who need the support of the Trust mental health teams, and specific therapeutic spaces in each of our establishments to provide multidisciplinary support to people at risk. I look forward to receiving the RQIA report, which I will of course consider carefully.
Declan McAleer, supplementary.
I thank the Minister for her response, and she had preempted my next question as to when we're likely to see this published. So the Minister has stated September 2021, which is actually 5 years from his first commission. So can she give that commitment now that this will be published in September?
Well, it isn't a commitment, Mr Speaker, that I can make on behalf of the RQIA, but it is my understanding that the report will be completed on the 20th of September and will be published directly by the RQIA during that week. So I would ask members to keep their eyes peeled because the RQIA, I hope, will be able to meet with that target.
Thank you. And I call Robbie Butler.
Thank you, Mr Speaker. Firstly, I'd like to thank the Minister for her timely remarks in regard to the death of a former colleague of mine. He was an officer who worked diligently right up to this point with many MLAs in this chamber, so thank the Minister for that. The Minister will also know that prison operations, including the provision of services for vulnerable prisoners, is impacted by staffing levels, and there are growing concerns at the moment with regard to staffing levels in McAleer Prison in particular. Can the Minister tell me, is she aware of the concerns that are being raised and what action she will take to address the same?
Well, we are aware that the arrangements that we put in place in our prison system, particularly to deal with COVID-19, have come under pressure at various points in the system, either through levels of illness within the prison service itself, and indeed the numbers of people isolating, or indeed through the peaks and troughs of people being brought into the system. The Director-General of Prisons and myself monitor this on an ongoing basis, and where there are any concerns about level of complement, obviously those are addressed. At this stage, the Director-General and his management team have not communicated to me significant concerns in respect of the complement that is available in the prison system, and certainly have not communicated to me that it would give them concern either for the safety of prison officers or indeed for the safety of prisoners.
I call Rachel Woods.
The publication of the report will be a matter, obviously, for Criminal Justice Inspection Northern Ireland, who have undertaken that review at my request. I understand that review is well underway. In fact, I think that the practical element of that in terms of attendance at the prison has been completed, and it is now a matter for the recommendations to be formulated. And I will, of course, keep the Chamber appraised when that report arrives on my desk.
Thank you, and I call Doug Beattie.
Question 3, please.
Mr Speaker, with your permission, I want to respond to questions 3 and 4 together. I'm extremely pleased that the Troubles Permanent Disablement Payment Scheme opened for applications on the 31st of August. That was an important day for victims and survivors of the Troubles who have waited such a long time for this important scheme. The Victims Payment Board is responsible for determining entitlements to payments under the scheme in line with Victims Payments Regulations 2020. As the Victims Payment Board is an arm's-length body of the Executive Office, the First and Deputy First Minister will be responsible for responding to queries relating to delivery of the scheme as it is now operational. I understand, however, that as of this morning the Victims Payment Board has received 272 applications. The Executive Office is also responsible for allocating funding to victims' groups to provide advice and support for the applicants to the scheme. I understand that £994,000 has been allocated this financial year for anticipated demand for support and advice arising from the scheme. That includes £300,000 for any increases in demand for health and wellbeing services. I would strongly encourage anyone who is considering making an application to the scheme to contact one of the support organisations. Contact details are available on the Victims Payment Board website.
Supplementary, Doug Beattie.
Thank you, Mr. Speaker. And Minister, thank you. I know there's been a huge effort in getting this brought forward, and like you, I welcome that. I have been speaking to many victims in regards to this, and I have to say there is still a degree of confusion out there as to who should apply, who should not apply, who can, who cannot, and what effect that will have on other benefits they may well have. Can I just ask the Minister, is there going to be any form of an advertising or media campaign to try and reach out, particularly because this is a UK-wide scheme, so people can understand the issues and the problems that's with it?
Well, Mr. Speaker, there were already a series of workshops for the public, virtual workshops for the public over the summer period, in order to ensure that the public could engage in advance of the scheme opening. The issue as to whether or not the scheme would be advertised more widely is a decision that would need to be taken really by the Executive Office, for whom the Victims Payment Board is an arm's-length body rather than the Department of Justice. Our role in this, as the nominated department, was that we would provide a scheme that would be operational, but the responsibility for those decisions around support for victims who apply, and indeed other matters pertaining to the Victims Payment Board, would be decisions for the Executive Office. However, I'm sure that they will have heard what you've said today and taken that on board as they move forward. It has to be said, with respect to any confusion in regard to who can and cannot apply, there is no barrier to application. There are, of course, eligibility criteria which may determine whether or not people are determined to be eligible for the scheme. That will be a matter for the Victims Payment Board itself to determine, but I think that the rule of thumb would be, if you believe that you may be eligible, you should apply.
William Humphrey.
Thank the Minister for her answer so far. Minister, over the summer I had conversations with a number of constituents around this particular scheme. I am concerned that staffing may well be an issue. Can the Minister, and I listened to what the Minister said about this being a TEO responsibility, but can I ask collectively around the Cabinet table, are Ministers content that the resource there is enough, and if not, are there other steps going to be taken? And I would echo the point that has just been made as well around certainty and clarity for those who would be eligible to draw down money from this scheme, and the implications it may have for them and other benefits they are currently drawing down from government.
Well, the member is of course right that it is a collective effort, I think, of the Executive to deliver this scheme, given that it is cross-cutting in nature. And I would certainly want to ensure that the good work that has been done is not undermined by weak delivery. And I think that that would be true of the board as well. There has already, as I pointed out, been significant funding given by the Executive Office to support victims' organisations so that they can have advisors on hand to give people advice if they are at any level confused or find it difficult filling in the forms themselves. It is a scheme that is designed that an individual ought to be able to complete the form without legal assistance, and I would want to stress that to people, that they don't need to go off and spend money on solicitors' advice. They can, of course, choose to do so if they wish, but there is other advice available to them without cost. And I think it's important that that is kept under review. If there is any feedback in the medium term that those organisations are in any sense overwhelmed, or that the advisors are struggling to deal with demand, then that is of course something that the Executive collectively would look at through the budget process.
I call Sinead Ennis.
And the Minister alluded to it there, so I know she's aware of law firms contacting victims, offering paid representation to help with the filling out of the application forms for the Victims Payment Scheme. So we know, as you said, there are several organisations who are funded to do this. So what direct engagement have you had with the victims to make sure that they are directed towards those organisations so that they're not having to pay unnecessary costs?
The Troubles, the Victims Payment Board itself issued a statement in light of some public commentary that solicitors had been contacting individual victims and offering them that support at a cost. And the Victims Payment Board put out a statement to make clear that there was no necessity for people to go down that route. Of course, no one is precluded from seeking legal advice if they wish to do so, but it isn't required in terms of being able to fill in the forms, and there is other advice, as I've said, available. It should also be noted that the Law Society issued a statement reminding solicitors of the rules around soliciting for business, and that is not an appropriate behaviour and could lead to fairly significant action against them by the Law Society. So I think that has been communicated both to solicitors and to families, but we will, of course, on an ongoing basis want to promote the services that are available through the various victims' organisations, and that the key point of contact for that is, as I say, either in the Payment Scheme Board itself, where they have information on their website, or indeed by contacting the victims and survivors services, so that they can direct people to the right place to get advice, which will not cost them money and will not in any way impact on any final settlement that they may receive from the board.
I call Colin McGrath.
Mr Speaker, would the Minister have any update at all about the overall funding for the scheme? There remains significant ambiguity about that, and we can't allow any of the stakeholders to shirk their responsibilities, such as the British Government, to ensure that it isn't our executive coffers that have to fund this scheme whenever others have responsibility as well.
The issue of the ongoing funding of the scheme is one that continues to exercise executive colleagues, including myself and the Northern Ireland Office. The discussions on that are ongoing. There is no final formulation in place, but I would hope that there would be so soon, and I agree with the member that it is important that a scheme which is open to people right across the UK and indeed this island who have been affected by the Troubles is not left at the door of the Northern Ireland Executive to fund from the block grant. However, it is most important that we reassure those members of the public who may wish to come forward and apply for the scheme that their payment is not at risk. It will be covered. There is an undertaking from the Executive Office in court to that effect, and we will ensure that it is paid. However, in terms of the fairness of distribution of responsibility, I concur entirely with the member.
Moving on, I call Gerry Carroll.
Can I assure you that there are no plans to close Bishop Street Courthouse? At the start of the coronavirus emergency, the need to ensure court buildings were safe for staff, judiciary and court users meant that jury-led Crown Court trials across Northern Ireland were suspended from late March 2020 to August 2020. Following a series of COVID-19 risk assessments, the Northern Ireland Courts and Tribunal Service undertook a programme of works on courthouses to ensure they complied with the Public Health Agency guidelines on managing the risks of COVID-19. This allowed for the phased reopening of most courthouses. However, several courthouses, such as Londonderry, Derry and Downpatrick, are listed buildings. Their layout meant that it was simply not possible to accommodate 12 jurors in the courtroom, while at the same time complying with PHA guidance on social distancing. Consequently, when jury trials recommenced, Crown Court business had to be moved to a location where it could be accommodated within the guidelines. In the case of Bishop Street Courthouse, Derry Crown Court business was moved to Coleraine. Magistrates, civil and family court business, which does not require a jury, continues to be heard in Bishop Street. Jury trials deal with some of the most serious and sensitive cases in the justice system. It is important for the victims of crime and for those awaiting trial that justice is dealt with in a timely way. It is important to recognise that the temporary transfer of Crown Court business from Bishop Street to Coleraine has allowed a number of trials to proceed. My officials have already met with the Law Society and are arranging a meeting with the Foyle Solicitors Association on this issue. The programme of work to incrementally recover court business is being informed by public health guidance. These arrangements will be kept under review and will be revisited as circumstances develop.
Supplementary, Gerry Carroll.
Thank you, Minister, for answering. The move may have been initiated by COVID, but the move has caused inconvenience, disruption and barriers for people, particularly in Derry, to get access to justice. So, just like to ask the Minister, when will the change revert back to having these court cases heard in Derry, and what measures has she and will she take to make sure that people in Derry aren't facing any barriers to get access to justice?
Mr Speaker, unfortunately I can't predict what COVID may do in the months ahead and at what point we will be able to dispense entirely with the social distancing requirements that have been placed on us by the PHA. We do recognise that it is an inconvenience to have to travel in order to attend court, but it is an inconvenience that people across Northern Ireland, and not just those in the North West, have been requested to do as a temporary measure in order that we could start to recover the court system and have their cases heard. In the vast majority of Crown Court cases, people would far rather be able to travel the short distance between Derry and Coleraine than see their case not taken at all, which is the alternative. And therefore, I think it is important that we move forward in a constructive way. But I want to reassure members, because I'm not sure where the rumours started, Mr Speaker, as with all rumours, but it seems to have got legs that we're for closing Bishop Street Courthouse. Nothing could be further from the truth. In fact, my department is engaged in a process of looking at how we can upgrade the courts and tribunal system and particularly provide a suitable hub in the North West. And I have no doubt that my colleagues from Foyle will want to bend my ear at length about where that may be located.
Thank you. And I call Sinead McLaughlin.
Thank you, Minister, and you really have answered my question, because I was going to ask you to give an absolute commitment to delivering that modern court service to the people of Derry. And I note in your reply to my letter that you talked about the North West, but we need an absolute commitment that you mean Derry when you say about modernisation and upgrading the Bishop Street Courthouse.
Mr Speaker, it may not be possible to upgrade the Bishop Street Courthouse, but still to provide a modern and effective centre for justice within Derry, Londonderry, and that is certainly the option that we are considering at this time. But we are absolutely committed that Bishop Street Courthouse, once COVID has passed, will reopen in its current state. And in terms of our future visions, members will be aware that we recently published the Modernisation Vision Statement, which gave ambitious plans to deliver independent, fair and effective modern courts and tribunals right across the jurisdiction. The document also acknowledges the restrictions in the current estate and also the technological capacity required of a modern justice system, and looks at how we can deliver that better. The strategic outline case for major capital investment in the North West has been approved, and the business cases for other schemes at the Royal Courts of Justice and Old Town Hall in Belfast have commenced. So we are now working through multifaceted technical surveys across the entire estate to ensure a rigorous assessment of accessibility, physical conditions, space efficiency and functional suitability. So I can give an absolute guarantee that Bishop Street Courthouse will reopen and that there will be new facilities provided in the longer term in the North West. Of course, Mr Speaker, it would be remiss of me not to remind the member that I may not be the Minister in charge at that point.
Okay, and I call Philip McGuigan.
Collier. The Minister will be aware that the contract for the Nightingale courts that were used during the pandemic ended on the 3rd of September. Can I ask the Minister if that contract has been renewed, or if these will continue to exist into the future?
With respect to the Nightingale system, there are a number of options available to us, and I'm happy to come back to the member with more detail on how that will work. But you will understand that in most cases, though not all, the Nightingale courts were dependent on there not being an alternative use that was allowed under the coronavirus regulations for those particular facilities. As increasingly society opens up again, some of those facilities may not be immediately available to us. However, international conferencing is one area that is is likely to move at a much slower pace, and so there is still scope for us to continue with that. In the interim, we have, however, provided other temporary accommodation to allow again for an expansion, particularly in terms of workspace for those who work in the court system. There's a huge amount of work to be done and has been done, but we will now be in a situation where, in terms of Crown Courts, we will actually have one more than we had pre-pandemic at the end of this process, and I think that will allow us to start to make a real impact in terms of recovery.
Next question, Nicola Brogan.
Question number 6, please.
Keeping our young people safe from online child abuse is a shared responsibility across all government departments. This is reflected in the Executive's online safety strategy and accompanying action plan, which aims to ensure that children and young people can participate in the online world in a positive, safe and responsible way. Officials from my department are also represented on the Health-Led Child Protection Senior Officials Group, a strategic forum which provides direction on existing or emerging child protection issues. The group's work plan includes online safety as a key priority area. My department seeks to protect children wherever possible within its policy and legislative remit, whether in the online or offline world. Following the report of the Independent Inquiry on Child Sexual Exploitation in Northern Ireland 2014, my department consulted on a review of the law on child sexual exploitation. This led to the inclusion of a number of legislative proposals now contained in the Justice Sexual Offences and Trafficking Victims Bill, which has come forward to the Chamber for consideration today.
Supplementary, Nicola Brogan.
I thank the Minister for her answer there as well. Recent figures provided by police forces right across Britain and in the North have indicated that there's been a 16% rise in online child sex abuse cases. So can I ask the Minister, has she had any input into the British Government's online legislation, and if not, has she made any representation just to show the importance of this issue?
The issue of the Online Harms Bill, which is being taken forward at Westminster, is one that I have taken particular interest in because, as members will be aware, communications online and telecommunications generally are not devolved matters, and therefore that bill will provide the platform upon which we can then legislate against harm. So we have been in contact with our colleagues in the Home Office. I have written to my ministerial colleagues and my officials, maintain a watching brief in terms of the proposals that are made. I have some concerns that those proposals do not go quite far enough, and so a key area included within the bill's draft provision that we're bringing forward today at second stage relates to adults masquerading as children for sexual grooming purposes, and in total subject to Assembly approval, 4 new offences will be introduced: communicating with an individual, communicating with a group, communicating with a view to grooming a particular child, and communicating with a view to grooming any child. Importantly, the communication does not need to be sexual for those cases, nor does the communication need to be online, though it is accepted the majority of cases will relate to online activity where behaviour of this type can be carried out more easily.
Call John Buckley.
The Minister may be aware about the dangerous rise in online self-harming websites, which are preying particularly on young people and the most vulnerable within our society. Recently in the Chamber, the Health Minister, at my request, did meet with one of the families directly affected by that. Will the Minister give a guarantee that the Department of Justice will feed into those conversations with Department of Health officials to ensure that we can help eradicate this scourge, which is sadly claiming one too many lives?
Well, I want to thank the member for raising this particular issue. It's a hugely emotive issue, and I think it is repulsive that people online would prey on young people who may be distressed, who may be suffering from the temporary issue of poor mental health, and seek to promote with them this kind of culture of despair and devalue their lives, and the pain and the harm that that can cause, not just to the young person but to their family and to the wider community of their friends and associates, is enormous. And so I think it is important that there are proper protections put in place. The member will recognise that not all of these matters fall to the Department of Justice's lead, but I am more than happy to step up and work with my colleagues, whether that be in health or communities, to look at how we can ensure that those who try to promote this culture of death and despair online are stopped in their tracks by the law.
Call Justin McNulty.
Minister, I welcome the fact that legislation via the Justice Sexual Offences and Trafficking Victims Bill is being progressed. Anything that can be done must be done to help protect children and young people's safety online. I am concerned about the exceptions, however, in relation to for mere conduits and for caching or storage by internet providers within Section 5(9) for service providers. Is this insertion proportionate, and is there a risk that it is, in actual fact, removing the onus on the service providers, the Facebooks, the TikToks, the Instagrams of this world, removing the onus on them to police their own content, the content on their platforms, and therefore it's a sort of a get-out-of-jail card for those providers?
No, I would want to reassure the member that that is not the purpose of those particular clauses. In fact, it is required that we include those clauses because of our exit from the EU and ensuring that ISSPs who are governed through laws other than those in the UK are then also subject to UK law. So that is the nature of those particular provisions. It is certainly not to offer a get-out-of-free jail card, and I have certainly made my concerns known to the Department of Community, Media and Sport in Westminster with respect to the rather light touch approach that they have taken in their online harms bill with respect to being able to enhance the traceability of people who are involved in crime online. I think that there is, and I think we would all acknowledge, Mr Speaker, there is often a good reason why people choose to be anonymous online. However, there is a distinction between having an online anonymous persona and not being traceable in terms of the owner of the account and the information that is provided where there is a breach in the law, and that's something I continue to explore with the Department. I also think that the regulation of content on providers' sites is also hugely important. In fact, it is an issue that I have raised directly with Facebook and Twitter in terms of my concerns that they don't take their responsibilities as a platform seriously enough.
And that ends the period for listener questions, members, and we now move on to 15 minutes of topical questions, and I call Anya Murphy.
Could the Minister explain why the introduction of the new domestic abuse offence from the Domestic Abuse and Civil Proceedings Act will be delayed from the end of 2021 until at least February 2022?
Mr Speaker, it is of course hugely regrettable that it has taken longer than we would have wished for the operationalisation of these clauses, but it is solely as a result of our partners who engage in the operational space and who have indicated that the time limit or the time deadline that we had set of December will no longer be possible. There are a number of reasons, but the majority of it is down to the complexities of the various computer systems and the interchange of information that is required in order for those particular offences to take effect, and therefore they have asked for additional time. However, they have reassured us that the revised time frame for this is a more realistic one, and obviously also all of them are working under the pressure of COVID, but the majority of this is simply down to the operational complexity and the technical complexity of some of the information sharing.
Supplementary, Anya Murphy.
I'd like to thank the Minister for her answer. Are you confident that the introduction of the hugely important domestic abuse offence will not be delayed further and will be indeed in place by the end of February next year?
That is absolutely my intention.
Call Jim Allister.
What's the Minister's assessment of the level of Unionist and Loyalist confidence in the Chief Constable?
Mr Speaker, I think that it is clear that there are those within the Unionist community and the Loyalist community who, for a number of reasons, would say that they do not have full confidence in the Chief Constable. My job, however, is not merely to assess that situation. My job is to work with partners, both the Chief Constable and indeed the other parts of the tripartite arrangements that are here, and members in this chamber, to build that confidence. And I will say very gently, as I have said on previous occasions, that I do not believe that ignoring the tripartite arrangements, ignoring the role of the Policing Board in terms of accountability, ignoring the role of the Ombudsman's Office in terms of looking at serious breaches, and instead going straight to party politicking around the Chief Constable's position, does anything to enhance not only confidence in the Chief Constable, but the standing of political colleagues in this chamber. I think it's therefore important that, as members ask the question about confidence, they also reflect at length on what contribution positively they can make to increasing confidence, because I believe that that is a role which all of us are called to in this House.
Supplementary, Jim Dolan.
Loyalist confidence matter, or is it only Nationalist and Republican confidence that matters to the Chief Constable and the Minister? And when she talks about reflecting, she must be aware of the irreparable damage done by surrendering streets of West Belfast for the terrorist funeral of Mr Story. She must be aware of the compounding of that with many other issues, such as the mistruths about why there wasn't a helicopter to oversee an INLA show of strength, and she must surely know of the deep loss of confidence provoked by the Chief Constable's plan to hide from
put the
public
question,
view
please.
memorials to gallant RUC dead. Is she really surprised?
Put the question.
Since those haven't been addressed.
Member, put the question.
A total lack of confidence.
Member, I won't have to engage like this again. When you're asked to put the question, you please put the question.
Thank you, Mr Speaker, and hopefully my answer can be slightly briefer than the question. On the first point, does Unionist confidence in the police service matter? Of course it does. It is important that every member of this community, irrespective of their political views, has confidence in the Chief Constable and in the PSNI, which is why it is so important that those who stand up in this House to talk about policing issues do all in their power to engender confidence. The second question, as I understand it, was I surprised? I presume, at the litany of things that the member has raised in terms of grievance. And no, I'm not surprised that he has raised those issues, because he has raised those issues repeatedly in the chamber. But he has sought no solution. He has brought no new information by way of progress to the chamber. And I have to say that I think that this constant erosion of confidence, deliberate erosion of confidence in the Chief Constable by some, will ultimately be to the detriment of the Unionist and Loyalist community. Because if people end up in a situation where they no longer have sufficient confidence in the PSNI, then they will turn to others, and the risk of that is much, much greater. And every member of this House should be conscious of our history and how that has played out in the past. So let's not play politics with policing. Let's remove the politics from policing, resolve the political issues as politicians in a mature and pragmatic way, and deal with the challenges of policing, which actually affect confidence. Things like response times, things like the police's ability to provide confidence in the community around community safety, that all of those things can be delivered in every community. And I would simply wish to correct the record, if I may, Mr Speaker. I did not have sight of the Chief Constable's report before it was presented to the Policing Board, because the majority of the elements therein were of an operational matter. But I wish to confer to the Chamber that we should not build up straw men to then appear brave, wrestling them to the ground. How this report has been characterised in the media and again in this chamber today is not just unhelpful, it is inaccurate, and I think members should desist.
Thank you. And I call Mr Pat Cataney.
Thank you, Minister, for appearing today. Can I ask the Justice Minister for assessment of the South Armagh policing review?
Well, the member will be aware that, as I have just stated in the previous question, it is not something that was brought to me to be consulted or to my department for consultation. No proposals have been put to me in connection with it. As Justice Minister, I have always taken great care to respect the tripartite accountability arrangements, and that includes respecting the Chief Constable's independence in respect of operational matters and the Board's role in holding him to account. In the normal course of events, I would expect to be consulted on proposals that directly engage my department's responsibilities before they are put into the public domain, particularly where they are sensitive or controversial. There are lots of aspects of the report which should not be controversial, Many of the recommendations are about professional policing approaches to a particular geographical area and make proposals which would modernise that policing approach. Many of the proposals would lead to more visible and responsive policing for the area. There are some controversial recommendations which would benefit from further, very careful consideration before any final decisions are made about them. I welcome the recent statement by the Chief Constable clarifying the PSNI's intentions in relation to some of those more contentious recommendations. I also note the Chief Constable's commitment to provide detail on his plans to the Policing Board in the coming weeks.
Pat Ketney, supplementary.
Thank you. Minister, do you agree with me then that closer cooperation between the joint operations between the PSNI and the Garda Síochána will help to disrupt the activities of organised crime groups involved in the movement of illegal drugs across the border?
Mr Speaker, the report invites the two Justice Departments to explore the scope for joint policing arrangements to include hot pursuit protocols. There are a range of legal, practical and political issues that would need to be considered and agreed by both governments in terms of joint approach, as opposed to collective and collaborative policing, which is already underway, including most obviously what powers police officers would hold in the jurisdiction in which they are not attested. I will continue to discuss with my counterpart as of our regular engagements, but at this point I remain committed to supporting the increased effectiveness of our respective police services to tackling cross-border criminality within the existing and agreed operational frameworks, including through the established Joint Agency Task Force, which brings together the relevant law enforcement agencies to better coordinate strategic and operational actions against cross-border organised crime. Hot pursuit protocols have some obvious attractions, but also face some significant legal and political and operational obstacles, which explain why this has never been possible to date. I do not rule out looking at this area again if there is sufficient political support for it, but that does not seem to be in place currently.
I call William Urban.
Speaker, can I ask the Minister, has she had any discussions with the Chief Constable in regard to public competence on the PSNI in Unionist areas?
I have had regular discussions and ongoing discussions with the Chief Constable. I continue to work with him and through this Assembly to promote confidence in the Chief Constable and in the PSNI as a whole. And as I have said to other members earlier, I welcome any efforts which individual ministers or individual members can take in their communities to try to enhance that confidence and encourage people to work with the PSNI constructively and productively in order that we can reduce crime and make people safer, because ultimately that is a joint endeavour and not one solely for the Chief Constable.
Supplementary, William Urban.
I thank the Minister for her response. Can I ask the Minister, does she accept that there is an issue with confidence in policing in Unionist areas of Northern Ireland?
I accept that there are issues with confidence in terms of policing in certain parts of the Unionist and Loyalist community. And I think that it is not fair to say that that is universal, nor is it fair to say that it is as widely held as some would wish it to be. However, irrespective of the extent to which it is a problem, it is important that it is addressed. And so I would encourage those who represent those communities who feel that they are, for whatever reason, lacking in confidence in the PSNI or concerned about PSNI operations, to work through the Policing Board, on which all parties have membership, who are in the executive have membership, and also through PCSPs and other opportunities that are available to build that confidence and to restore that confidence in the Chief Constable, his senior management team and the PSNI more widely. Mr Speaker, policing is not an easy job to do. I am not the Policing Minister, and for that I am eternally grateful. I am the Justice Minister, and my job is to focus on justice. But in order for justice to operate in a society such as ours, it requires that there is confidence right across the community, in every part of the community. And I believe that all of us have a role in ensuring that that is the case.
Thank you, Nicola. John O'Dowd.
I understand that it will not now be possible to legislate for exclusion zones around healthcare settings where women are accessing healthcare, in this case abortion services. Has the Minister examined any other legislative way to protect women who are accessing healthcare?
I thank the member for his question. It may not be possible. It is currently a matter of discussion as to whether or not it is possible to bring it within the scope of the current legislation. However, I am aware that there is a private member's bill that is sitting drafted ready to take this forward, and I have also made contact with my colleagues in Westminster because, as members will be conscious, they are due to bring forward legislation with respect to the provision of abortion services where those have not been commissioned by the required date. It is important to note that all parties in this chamber, I think with perhaps only one exception, have voted in favour of motions in chambers in councils across Northern Ireland, which are clear that harassment of people entering medical facilities needs to end, that there needs to be space for people to be able to access medical treatment, and for staff to be able to go to their place of work without interference. And therefore, I hope that such changes will not be controversial, but will allow people to continue to protest, but to do so in a way that is responsible and doesn't interfere with access to healthcare.
Just get a brief supplementary, please, John O'Dowd.
Everyone has a right to protest, Minister, but protesting outside a health setting, I think, is unacceptable. No one protesting and shouting and roaring at women walking into a healthcare centre knows those women's stories. But I welcome the Minister's commitment to examine all legislative pathways, and will her officials engage if the private member's bill is laid further on today with the member who is proposing that private member's bill?
Well, of course, and I am absolutely committed that this issue will be resolved. I do believe that the right to protest is an important human right. It is an important part of being in a democratic society. But the member is, of course, absolutely correct that many of the women who are accessing this particular kind of healthcare, and indeed many of those who are not seeking a termination of pregnancy, but who are seeking other medical advice that may be related to that or to other sexual issues, find it incredibly intimidating, distressing and frustrating to have to run the gauntlet of protesters, often in what is a most distressing time in their lives. It is not appropriate. Those who genuinely have compassion for those women, and indeed for the unborn, I think should reflect on how they conduct those protests, how they make their voice heard, and at what point in the system, because I don't believe that running the gauntlet of protesters on the way to healthcare is an appropriate mechanism.